Okay, we have made it to our last panel of the day, and we are perfectly on time, which is good news because I know I'm thirsty, and I'm guessing many of you might like to maximize our happy hour at the end of the day over at HAPS. I'll provide again some directions on that when we finish up today. But our last panel is collective security in the space domain, addressing the space security challenges through international cooperation. To moderate this panel, we have Major Nicholas Mahanic, the Chief of Space and Operations Law for Space Operations Command, or SPOC, another of our aptly named space-related commands. As a field command of the United States Space Force, Space Operation Command generates, presents, and sustains mission-ready space forces, providing missile warning, positioning, navigation and timing, communications, space electronic warfare, space control, command and control, and space domain awareness capabilities for the United States Space Command and other combatant commands. Over to you, Major Mahanic.
Thank you, Professor Biller. So really glad we get to follow the Ukraine panel since that had a lot of interesting information and it implicates what we're going to talk about since collective security is really back in the news. People are really talking about it, the resurgence of NATO and what this war means for that and what it means for other AORs as well. So we're really excited. We have a really great panel to discuss with. We have Squadron Leader Tara Brown, who's a military professor of law at the Stockton Center, U.S. Naval War College. We have Lieutenant Colonel David Amamoo, who's legal advisor at SHAPE, Supreme Headquarters Allied Powers Europe, advising on NATO. And then we have Major Kyle Owens, who's at Indo-PACECOM. So they have great varied experience both through their careers and academically to talk about the subject. So with that, Squadron Leader Brown is going to go ahead and sort of set the stage and talk about some of the background on collective security. And then we'll talk a little about their experiences and get into some questions.
Thank you. Good afternoon. Thank you very much to the organisers for inviting me to speak today. Just as standard, that any views I express today are my own and not necessarily those of the Royal Air Force, His Majesty's government, or the US Naval War College. We're here to address space security challenges and how international cooperation implicates this. And national and global considerations are not always complementary, and sometimes there can be a tendency when seeking to protect interests at the national level to pursue dominance or to pursue control, which in some circumstances may potentially hinder cooperation in the international arena and cause a more delicate situation for global security. And of course, much depends on who we're trying to cooperate with. Are we trying to cooperate with our allies, or are we trying to cooperate with the wider international audience? I'm going to briefly touch on some historical examples and more recent efforts to address international cooperation, as well as addressing available collective security responses to specific threats. The extensive capabilities that we get from space are critical to collective security. And with space, you have this domain upon which we're uniquely dependent, but you also have a multitude of threats. You heard General Dickinson earlier describe space as being congested, contested, and competitive. And for this reason, space has been described also as an Achilles heel. So where does cooperation fit in? Some of the collective security challenges to space include the debris issue, the increasing presence of non-governmental entities and the regulation of those actors, the ambiguity within some of the provisions of the Outer Space Treaty, competition over allocation of orbital slots. In geostationary orbit, you had the issue of assured access to radio frequency spectrum through satellite filings. And of course, you've also got the threats posed by increasingly sophisticated counter-space weapons, as well as irresponsible behaviors in space. So take, for example, the debris issue. We have means of removing debris from orbit, but at present, we don't really have any affordable means of doing so. And we have some space traffic management, but we don't have a system that's on par with air traffic control. And so you've got this risk of conjunctions, and that's a risk that increases as more satellites are launched into orbit and as more debris is generated. And once in orbit, debris travels at speeds of 17,500 miles per hour. So it's really quite easy to imagine the damage that would be caused to a satellite by even a small fragment of debris colliding with it. And once debris collides with other debris, it splits and this creates more debris, so the problem's getting worse. Conduct such as ASAT testing is driven by national security considerations, but it introduces more debris and it further strains international relationships. And then you've also got the simple fact that the number of satellites in space is increasing. So Starlink, for example, has been positive for national security. The US Army, Air Force, National Reconnaissance Office, all have contracts with Starlink. And with it being a constellation of over 3,000 satellites in low Earth orbit, you might lose, say if you were to lose one satellite, you're not going to lose your capability, your overall capability. And with it being in low Earth orbit, you can send replacements up quite quickly and quite cheaply. So that's brilliant from a national security perspective. It's also, that resilience has also been positive for collective security. So Elon Musk's decision to roll out Starlink services to Ukraine, and in particular to the Ukrainian military at the outset, was a key part of its military's ability to defend itself. But there's also some downsides for global security because congestion is a live issue. That's something that's mentioned in the UK's policy as being one of the live issues. That's something that we're all cognizant of. So it's important to strike the right balance. I'm going to give a brief outline of some historical and recent efforts at international cooperation. But bear in mind that when working towards global cooperation and global security, there has to be some give when it comes to dominance and national security and perhaps even collective security. And that can be a really challenging balance to strike. So in the early 1960s, when the Outer Space Treaty was being negotiated, there were nuclear experiments in space. And it became apparent that the effects of these were harmful to the space environment as well as to space assets. So for example, the Starfish Prime project that altered the Van Allen belt destroyed or damaged nearly 1/3 of satellites that were in low Earth orbit at the time. By 1963, the Partial Test Ban Treaty was signed. And then in the early 70s, you had the SALT I Treaty, and then followed by the ABM Treaty bilaterally between the Soviet Union and the United States. And all of those represented strategic restraint during times of tension with the main players. More recently, the US has led the way in a unilateral commitment not to conduct any ASAT tests. And that's been followed by numerous other countries, including the UK, Canada, and New Zealand, for example. But typically where there has been change, that's been driven by events. So the tolerance in the international community for ASAT testing has waned significantly, with the most recent Russian test being met with very significant criticism. And despite some of the disapproval that's been levied at these states that have taken that step in making these unilateral commitments, which is focused on a concern that they're leaving themselves exposed from a national perspective, it doesn't prevent those states from using these missiles, of course, if they have them, if a self-defense situation arises. So it's a really good example of a decision involving some give in the interests of opening the door to greater international cooperation. Likewise, events driving change can work both for and against international cooperation. So for example, the US unilateral withdrawal from the ABM Treaty shortly after 9/11 was opposed by NATO, who saw the move as a break from collective restraint. There's a number of ways in which states can exercise collective security. So sometimes it might mean a direct response to a threatening act or omission by another state. So for example, self-defense can be exercised collectively. It applies in all domains. It's reaffirmed, but it applies in outer space by virtue of Article 3 of the Outer Space Treaty. As can enforcement measures taken, authorized by the UN Security Council pursuant to Chapter 7 of the UN Charter. However, countermeasures in response to internationally wrongful acts, there's a division of opinion as to whether they can be exercised collectively, with most would conclude that they cannot. Collective security can also encompass passive measures, such as information and intelligence sharing, debris mitigation initiatives, working towards the interoperability of space systems, and also working together to identify any interference. But working towards global security is broader still, and it requires international cooperation to build a secure space operating environment. I've already mentioned some of the recent tests, recent commitments made by states to refrain from conducting ASAT tests. Looking at historical efforts, the Conference on Disarmaments Committee on the Prevention of an Arms Race in Outer Space ended in deadlock. And the Chinese-Russian draft treaty on the prevention of the placement of weapons in outer space, PPWT, that's been pushed for the last 15 or so years, was also unworkable. And while there is a balance to be struck, that's distinct from letting our guard down, and we need to be sure that anything that we do enter into isn't going to be used for strategic advantage. So therefore, in terms of hard law and looking at a new treaty, we're not going to get cooperation without transparency, and we're not going to get transparency without trust. And that's something that's not realistic in the current geopolitical climate, where states are seeking dominance in space. So what we're really working towards now are norms or rules of the road and transparency and confidence building measures, TCBMs. And they're the first step in effective engagement with the international community. And these can involve cooperation at the strategic level, so it could be more transparency with regards to national space policies, and then also cooperation more at the local level, including the sharing of information or greater consultation than we've seen in the past with regards to planned space activities. The UN Initiative on Responsible Space Behaviours, which was initially spearheaded by the UK, led to the creation of an open-ended working group focused on reducing space threats. And you had the first session, which involved taking stock of the existing international legal and normative framework. Second session, looking at what the threats are, what current threats we might face. And then the session that just took place, making recommendations on voluntary non-binding norms, rules, and principles of responsible behaviours. And these will work to, this shared understanding will reduce the risk of misunderstandings and of miscalculations and of mistrust. And TCBMs, therefore, are something that we can use to enhance not just national security, but also international security, and reduce that opportunity for a competitor or a potential adversary to misinterpret intent. They can be tested as needed, they could be modified. And additional to that work, you've also got the 2 space law manuals that are going to increase discussion and increase dialogue amongst states. I believe I'm out of time, so I'm just going to pass over to the next panelist.
Yeah, if you guys want to go ahead and share your experiences, what you've seen in some of the challenges in collective security in the space domain, principally in your respective theaters, but wherever you've seen it. And then we can circle back to some of these topics more in depth.
Good afternoon, everybody. Unfortunately, I won't sound quite as polished as Tara here, but I'll try to cover some of the things that we see out in the Indo-Pacific. And, even though this is a non-attributional environment, I do appreciate the opportunity to come here and represent US Indo-PACOM at this forum. I think it was noted earlier by Colonel Pennington. He talked about free and open, and that's something that we hear and that we also cling on to quite often in the Indo-Pacific is the idea of free and open Indo-Pacific. And whenever we talk about collective security and also cooperation, I think it's key to point out that that specific concept that I think most people are probably pretty well aware of is actually one that was created or come up with by Prime Minister Abe back in 2016. And of the couple pillars that exist under that concept, at least what he articulated, one of those dealt with security and stability within the region and also dealt with cooperation. So I think that's kind of important for the discussion here and kind of drives home some of the concepts that are key to operations within the US Indo-Pacific and also that shared sort of mutual security that we have. I know one of the things too that I wanted to kind of point out about the Indo-Pacific, and I know oftentimes we think about the relationships with allies and partners that we have, maybe in Europe, but also within the Indo-Pacific. I would point out the dozens of partners that we have there within the theater, but also the kind of key treaty allies that we have, and kind of how important that is to those operations that we have within the US Indo-Pacific and how that fits with the discussions that we have about collective security here today and cooperation more broadly. As far as some of the challenges that we see within the theater, I would say whenever dealing with our partners, our allies and partners, one of the key things that I would note is even though there might be very mature bodies of law that we have in common, we might have differences of interpretation regarding those bodies of law. So whenever we had the discussion earlier about interoperability, I know that that's something that we oftentimes are focused about. And I think as an example, kind of a prime example would be differing interpretations as far as self-defense. And then also, whenever you talk about non-kinetic specifically, whether there's a gap or no gap that exists between Article 2.4 use of force and then also Article 51 armed attack. So that's kind of a key sort of consideration, I would say, whenever we're talking about interoperability and working with allies and partners there within the theater. And then also too, as far as the PRC and kind of some of the activities that they have within the theater, of course, there's the kind of consistent attempts that they have with their lawfare activities to both use and co-opt some of the organizations that exist, whether that be within UN bodies or elsewhere, to kind of push forward what are for normative rules might be the argument, but is also pushing forward an agenda that they have to kind of shape the space that they can use ambiguity within those areas and give them the freedom of maneuver in those specific bodies. And then also too, I think even though it's not solely related with space, but kind of tangentially so, the recent high altitude balloon issues that came up, if you saw repeatedly, they would use terms like near space to describe where the high altitude balloon was actually flying, as if that had some sort of legal import attached to it, which I think most folks here would recognize that it doesn't. But again, those lawfare activities, that being something, an example of them doing so in informational spaces to kind of push forward their agenda that they have. And so we have kind of active activities that we do as a legal shop to try to counter that, and then also to try to bring in other folks, whether they be allies and partners within the theater or also within different theaters to help support some of those efforts that we have. And then also I think about some of the physical sort of issues that we have that we deal with there in the theater that deal with collective security. And the specific one that comes to mind that's specifically relevant as of late over the past year or so is space debris, like she brought up, like Tara brought up, but also too, launch debris being a key one. And I bring that one up because some of the launches out of Hainan Island that the PRC has, not only do they potentially implicate bodies of law dealing with space, but also other bodies of law like UNCLOS. And so we oftentimes find ourselves trying to find out what specific issues that might impact and what sort of bodies of law would be relevant to some of those discussions regarding whether it be launch or debris from post-launch. We also too, we have a great deal of positive things that are happening within the theaters with allies and partners. I know that was kind of elaborated on already by some of the other speakers earlier today. Some of the recent ones have been some really great engagements at the GIST, which is SPACECOM's body that they have that's organic, their Indo-PACOM that's attached, their joint integrated space team, to where they've had some great engagements with the Phil Space Agency, which is a new agency there within the Philippines to manage their space affairs. So some goodness coming out of that. And I would say also too, kind of what's already been addressed through today, talking about both the commercial corporations providing certain services to folks, but then also I'd say domestic capabilities that are being developed in some of those countries that are key treaty allies there within the theater. So some great positive things that are coming out of the theater that I think speak to what sort of efforts are being undertaken to help get after that security, that collective security sort of issues, and support that in the future.
Good afternoon, everyone. And I'd like to thank the Air Force Academy and SpaceCom for having me. I'm pleased to represent NATO and Allied Command Operations, which is NATO's strategic military headquarters. I think NATO, just some brief history. In the past few years, NATO has made a couple important statements recognizing the importance and the essential nature of space and its capabilities to NATO operations. So first in 2019, NATO declared space as the 5th operational domain. So now we have air, maritime, land, cyber, and then space. And then in 2020, we established the NATO Space Center. So that's more on the operational side. That's currently a subordinate element within Allied Air Command in Ramstein. And the main focus there is because NATO itself does not have any space assets or capabilities. That's our whole role is to then coordinate voluntary national contributions of space capabilities into NATO operations. So the NATO Space Center was designed as a one-stop shop, really, that had the connections to different national space commands so that our subordinate commands could easily go back and quickly and efficiently request space services. And then I think the most important development has been in June of 2021, which was in the NATO summit in Brussels. In the communique that followed that, NATO for the first time acknowledged at least the potential that a space attack could invoke Article 5, the collective defense article. And I think this is touched on in the introductory remarks. So this is where our current 30 members acknowledge that an attack to, from, or within space could then, the impact of which could then lead to Article 5. Now, I think this is obviously vague, and we saw the similar type of language in response to potential cyber attacks. So it's not defined, what would amount to an armed attack within space, whether it would be on national assets or commercial assets. But I think part of the ambiguity is on purpose. One of NATO's core tenets is deterrence. And we can't detail exactly what could possibly trigger a response. We want there to be some ambiguity so that there's a broader range of possible actions that might be covered. Now, given those developments, I think one key thing, there's a couple key tenets of NATO's space policy. And the first one is that NATO has no intention of becoming an independent actor in space or developing its own space capabilities. So a key tenet of ours is that we will be entirely reliant on national contributions. But then, given this topic of cooperation in space, that's where the second tenet, where I think NATO finds its most useful role, is that NATO wants to function as a forum for right now our 30 allies and then also additional partners to then discuss and collaborate on both their space capabilities and their preparation for defense in space. And then specifically relating to Ukraine, I think certainly, as we discussed in the previous panel, we've seen the reliance on commercial assets. I think one key disclaimer that I have to point out here is that NATO is not a party to the conflict in Ukraine. Neither is the United States or our other 29 allies. So I think this ties in with our discussion on neutrality. NATO, at least, NATO has no position, again, since we're not a party, but from SHAPE, specifically the US, we've focused on this doctrine of qualified neutrality as kind of the justification for the support that our allies are offering. From NATO, there's no assistance really being offered to Ukraine. Our role is entirely collaborating with the 30 allies and coordinating their different efforts in supporting Ukraine, the information and supplies that are being given to Ukraine. So again, just like we view our role for space and collective defense in space, NATO sees itself as a forum for that political military discussion amongst the allies. I think subject to your questions.
All right, thank you, everyone. So I want to circle back on a couple of topics. I noticed a few of you mentioned collective self-defense or countermeasures specifically, or measures below the use of force. And in fact, that also came up with the last panel, some of the struggles in dealing with that. So I want to ask first Squadron Leader Brown to elaborate on the issues with collective self-defense in using countermeasures, and then some discussion about ways, the challenges with that, but also how we can overcome that through cooperation to have an effective framework to act.
Yeah, thank you. I'll start with countermeasures then. So countermeasures allow a state to take non-forcible action in response to a prior internationally wrongful act. And that's the action that is being taken would normally be an internationally wrongful act of itself, but it's precluded by virtue of the internationally wrongful act that it's responding to. And countermeasures are, they have customary international law status, but they are reflected in the International Law Commission's articles on, draft articles on the responsibility of states for internationally wrongful acts. In particular, within Article 22. And if you look at the commentary that the International Law Commission provides, it says that the right to take countermeasures in the general interest or in a collective interest is uncertain. And it says that if you were to take countermeasures collectively, then that would be controversial. And that's something that accords with the International Court of Justice decision in Nicaragua, where it was determined that Nicaragua could take countermeasures, but they had to be taken by the victim state. They can't just be taken collectively. So I'd say that countermeasures cannot be exercised collectively, but that doesn't mean that you haven't got a means of responding when you're talking about activity that's below the threshold of the use of force. You've still got the UN Security Council that can issue a resolution for either forcible or non-forcible action under Chapter 7, Articles 41 and 42 of the UN Charter. And that could include, so it's taken in response to a threat to the peace, a breach of the peace, or an act of aggression. And it can include things such as sanctions and severance of diplomatic relations. I don't know if you want us to stop there, and then if anyone's got anything to add on countermeasures and other things like.
You've got more to say, keep saying it.
I just, before we go on to self-defense, maybe.
I think the only thing that I would maybe add to that, because I agree with you that, yes, specifically the draft rules, I don't think really anticipate taking collective measures, and that it's something that I think one of the last speakers was kind of addressing that as well. But I think there might be a marked difference factually, though, too, that may exist between supporting other folks taking active countermeasures and actually being the ones to conduct countermeasures. So I think that maybe that's an option too that could maybe be explored in the future for something that would help support this idea of collective security too, and be something that would comport with what the body of law looks and exists as now.
From NATO's perspective, I think that NATO has defined space as kind of a global domain. So in traditional conventional sense, obviously NATO's focus in the North Atlantic Treaty was on the North Atlantic area, so Europe and then the United States and Canada. And then specifically Article 6 in response to armed attacks is the only place within the treaty that has geographic limitations. So it's attacks on the territory of the Allies or their islands within the North Atlantic, so north of the Tropic of Cancer. But what we saw in the 2021 communique was this acknowledgement that the space domain really kind of surpasses that conventional sense of geographic limitations, just because attacks or potential actions in space have kind of global implications, not just for the Allies, but for our partners and other nations. So when we look into countermeasures, again, there's no defined answer here, but part of the discussion we've had is that any potential attack or under the threshold actions in space could be seen as aggressions against more than one victim state. I mean, in that sense, if the entire alliance is reliant on a specific satellite network, it would then be our view that it was the alliance that is the victim of that action in space, not just potentially either the commercial entity or the state of registry of whatever the space asset might be.
Okay, thank you. So I want to go back to another point that came up, which was we had these treaties back in the 60s, which imposed some arm limitations. There was some moderate success in that area. And then since that time, we've kind of backtracked in that area, most recently with the failed attempt by Russia and the PRC to push the PPWT. But instead, we've moved, at least the US and the UK and partner and allied nations, who move more towards these responsible behaviors and kind of doing things without formal treaties, but just molding people's behaviors in a certain way. Can you elaborate on, I guess, what lessons we can learn in terms of collective defense or collective cooperation from the failures of those treaty regimes, and what challenges do we face in trying to do it this other way instead?
I don't mind. Yeah. Okay, so the draft treaty that's been pushed forward by Russia and China had a lot of flaws in it. So, for example, the prohibitions that were included were in relation to space-based weapons and not air-based, sea-based, or land-based. And it also didn't apply to the testing of those weapons or to lasers and things like that as well. So it was really quite narrow. And the Chinese ASAT in 2007, that introduced all this debris into orbit, predicted to stay in orbit for around 40 years. That wouldn't have been included in the scope of the prohibitions. But more than the narrow application of it and the narrow scope of it, it didn't have any verification methods to check for monitoring and to check for compliance. So it was effectively meaningless as a result. And it's not that a new treaty would be wrong necessarily. I'm not saying that's my opinion that one is needed, but it's not something that's suitable to enter into. And also you've got the behavior, what's being pushed is at odds with the behavior as well. So China's ASAT, Russia's ASAT, most recently in 2021, introduced another 1,500 trackable pieces of debris. China's use of laser, testing of lasers, development, the fractional orbital bombardment systems are capable of being launched on hypersonic glide vehicles and bypassing missile defenses. It's at odds with what's being pushed. And so you don't obviously want to enter into something that's going to be used against you, especially where you've got no verification and it's effectively meaningless. So that's why we're looking more so at TCBMs and that kind of thing now. I think you're probably able to add more on.
So I would just add, I think everybody's probably well aware too of the historical anecdotes that exist for treaties for which the PRC are signatories to, them also not upholding those specific treaties. So, Indo-PACOM, we deal with on a daily basis. South China Sea, and specifically, I think to some of those claims that the PRC tries to exercise within that part of the world, and it being something that's incompatible with UNCLOS and something that other opportunities they try to rely on and use it as a sword, essentially. So I would just point out, and whether that's very persuasive or not, just that there's the historical precedent for them continuing to use what is something that they've already agreed to and is upheld as a standard of law, but then also not upholding their end of it. So
I think this morning and afternoon, we've kind of highlighted some of the gaps in space law and the new questions being raised as activities and the access to space increase. But given the current geopolitical context and the fact that we have China and Russia as two of the most prolific space utilizers as permanent members of the Security Council, I think, I mean, it's a pessimistic view, but it's unlikely that we're going to see any Security Council action for space actions or a new treaty of significance anytime in the near future. But I think that presents a great opportunity for not just NATO, but other like-minded nations to now really push forward as leaders in the development of law to fill in these gaps through state practice and academic writings. And I think Professor Nisu had a great point, recommendation for us all in the past presentation about thinking strategically. And I think that's where this is a great opportunity for the Alliance, now through our cooperation and coordination, to look at the use of commercial assets in Ukraine, look at the support our allies are providing to Ukraine, and then look forward. Think about the next fight, the fight after that, how we envision our uses of space, and how we envision the law both protecting the activities that we want to do to protect our alliance, and those that we want to at least highlight now. Enforcement would be a separate piece, but before we get to enforcement, highlighting and persistently objecting to those actions that we want to make sure are kept out of the space domain.
And on that, just mentioned commercial activity. I want to ask you all, with the proliferation of commercial actors entering this space, now we have, an additional complication. Now we have a multinational coalition. You have to get together potentially, but now you have commercial actors who may be tied to a state but not controlled by it. Does that make it easier or harder, or how can we avoid the pitfalls that come with that and leverage that for success in terms of dealing with collective security?
I'll start for that, and I'll probably just say it's tough. I don't think there's any clear answer for that. Often, I guess in the past, when space was primarily state assets, and I think we use this for all defensive things, at least from NATO's perspective, we want to be able to have reliability on the services being provided. So there's this, I think, hesitance that reliance on commercial actors presents this risk that, like we've seen with SpaceX recently, cutting off the access for Ukrainian use of Starlink for drones, to say that a commercial actor may leave. Yes, I think that is a possible risk. The main thing I think we see in the alliance is that's a risk dealing with sovereigns too. In general, yes, we agree to something, we think of us together, but even in conventional warfare, any of our allies can pull any units or contributions from NATO at any point in time in the middle of the operation. I mean, that's just always a risk when we deal collectively. The mitigation to that is the transparency and the pre-coordination beforehand, and then just that development of trust. So I think, as we discussed during the past panel, looking at Ukraine, I think learning from that and the now, it's more enhanced reliance on commercial activities. I think moving forward, that lesson learned will just go into the coordination between national governments and those commercial activities, how the contracts are defined, just to build that trust. the risk will always be there that the commercial entity could just go defunct, or the nation could decide they don't like the trajectory of whatever the engagement is and pull. That's a risk. But I think these lessons learned are at least allowing us to identify that as potential risk areas and develop the trust through different negotiation and agreements.
I would say just kind of one thing to note, whenever you're talking about dealing with commercial entities, I think whenever you raise the example of Russia, that may be one thing, but whenever, looking at Indo-Pacific and the PRC and the decoupling that may require, and that I know is an ongoing effort, but it's something that is, I think, a much more onerous sort of burden whenever you're dealing with the Indo-Pacific theater, specifically vice Russia, and the fact that the same sort of decoupling is really required for some of those commercial actors. And I know it was already talked about earlier by, I think, some of the other panel representatives for earlier panels, but talking about Australia and some of the other allies and partners that we have within the theater. The other one would be Japan, that I think is able to leverage some of the same sort of COTS capabilities that exist out there. So goodness in it, I would say.
And the only other thing that I'd add is just the obligation that states have to authorize the activities of these commercial entities and to continually supervise them. I think that's something that probably goes in our favor, because especially when you're getting a lot of military advantages from these commercial entities, you've got to be careful as to the right and left of arc of what they're doing and what the potential implications could be.
Well, based on past experience, there have been a lot of good questions from the field, so I'm not going to monopolize the question asking. But before I do, I want to ask the panelists same question I always ask at the end of any witness interview, which is, what would you like to share with the audience that I haven't asked you about? If you have anything. All right. And if there, oh, go ahead.
So the only thing that I might add, because I know the UN Security Council that came up before, I know that whenever we talk about lessons learned and things that can be taken from Ukraine, and we try to apply that within the Indo-Pacific and what the future may look like for the theater there. And we have to remain grounded in the fact that not all of the lessons learned from Ukraine will be relevant to the theater and what things may look like there in the future. But I think specifically about the UN Security Council and some of the difficulties that were had as far as ensuring that that body was able to effectively carry out its mission and its responsibility, and the difficulties posed based off of the composition of the UN Security Council. So I know that's something that at least we've thought forward about in our head, and how that might shape, in other words, what the situation may look like on the ground and at a strategic, and also at the level of allies and partners and the considerations that they have to make.
For cooperation, I should say, NATO and the 30 allies, soon to be 32, are obviously European focused, but just as we recognize any threats in space represent global threats, we've acknowledged that the cooperation needed to defend ourselves from space threats also needs global cooperation. So not only the allies, but we've invited in many of our partners, and some of our biggest ones also big space actors. So Australia, Japan, South Korea are all partners that are part of the collaboration effort for space defense.
Okay, with that, if there are any questions from the field, go ahead and take those.
Dancing with you. Hey, Chris Shank, Maxar. On the question of commercial not being there or being there, I don't know if you've looked at the case study. There was a book called Eccentric Orbits about the story of Iridium and that satellite constellation from the 90s. And they were looking to deorbit because they didn't have the revenue to keep the company going, kind of thing. And the Deputy Secretary of Defense at the time stepped in and worked to get them a contract, and to which the Iridium satellite phones were, ubiquitous then when it came to the war in Iraq a couple of years later. So I just commend that, and if you have any comments on on that case, on either if you're familiar with that kind of case study, because that's what, in terms of keeping will commercial be there or not, is a legitimate critical infrastructure, kind of question for the department. So
I'll go back and read the book. So then I'll be more familiar with it, sir.
history too. So it's,
Yeah, I'm not familiar with that, so I'll check that out. I would say just as we've seen from Ukraine, the reliance on commercial entities has not been misplaced. I mean, it's been completely essential. So I think while it's a valid to consider the risk of commercial fallout, just like it's valid to consider the risk of a partner nation backing down, I think what we've seen from this and other past examples is that commercial entities are great partners, and it's just important now in forums like this to recognize the risk and make sure measures are being taken to mitigate that in the preparation and planning for future operations.
So we have a couple of questions that have come in online, and online participants just want to let you know, apologies for not getting to any virtual questions last panel. Question for this panel though, given the doctrine of preemptive strike, what criteria would you say are specifically required maybe by a victim state in outer space to justify some sort of use of force or defensive countermeasure?
I was just going to ask to appropriately bracket that. I'm guessing they're talking about anticipatory self-defense specifically.
I think that's
Okay.
correct. Yes.
Gotcha. I don't know if you had something.
I think it would be very unlikely that you could probably justify something in anticipatory self-defense in space. You would need to look at the actors involved, the geopolitical climate, tensions. There's been things such as like rendezvous and proximity operations. There was one example where Russia came within close proximity of a US national security satellite and then maneuvered away. And it birthed this second satellite, which released a projectile into space, not in the vicinity of the US national security satellite. But I think even if you had a buildup of sort of these sorts of rendezvous and proximity operations, bearing in mind there hasn't been an armed attack in outer space, I can't see a situation where that would be justifiable.
I was just going to say one thing that I've noted, I think, within the theater is differences of opinion between allies and partners compared to maybe the US's interpretation for anticipatory self-defense. So I know that that's something that we run into and that I was kind of hearkening to whenever I mentioned those variances as far as self-defense interpretation, that kind of being a key one, anticipatory self-defense. I could certainly imagine a scenario, but I think it would be very fact-based, fact-dependent upon when that would actually excuse what would most likely be a use of force on our behalf then. So making sure that we're not the ones that are then violating Article 2 force prescriptions.
Just to add to that, in the UK, our sort of previous threshold that we used for anticipatory self-defense came from the Caroline case, and the standard was instant and leaving no room for maneuver. And I've definitely missed out one of the criteria. More recently, we had some criteria put forward by Lord Bethlehem, and it was a non-exhaustive list, but it was quite stringent criteria. And I think from the UK perspective, it would be quite a high threshold to meet in space in particular.
I just agree, it'd be incredibly high threshold. I think because of our different views of self-defense specifically, it's extremely unlikely that you would ever get NATO consensus on certainly any preemptory action. Just in general, not to rule it out as impossible. I mean, as a good lawyer, if I was ever called upon to justify it, I want to leave some maneuver room. But I would say in the current ambiguity of the status of space law, then it's probably unlikely in that sense. So I think beforehand, you would need a a lot of declaratory actions from space, or from a nation about the assets it has in space, the intended uses of those, and I guess probably the critical nature of them to at least justify preemptively how a threat to that could be possible for preemptory attack.
Good afternoon. Thank you all for your time today. So Eric Warner from U.S. Transportation Command, and I'm just talking about our commercial entities. You know, what's old is new and what's new is old. For the transportation industry, 85% of what we carry around the globe for Department of Defense, we carry by commercial partner. And so all these questions we've been talking about today, I think there are many parallels we can make in law and policy that we can start to think about and carry over to the space industry and space commercial industry and how that could be leveraged. You talk about war risk insurance authorities that we already have for Civil Reserve Air Fleet and the voluntary intermodal sea lift agreements that we have, the indemnification authorities we have, and then also looking at how do we protect those industries, what are obligations to protect them as they carry out their business globally. So we should continue to have that collaboration that takes place between existing organizations that we have and existing authorities that we have, and see how we can leverage that for the future.
Add, if we don't have any at the moment, which is Lieutenant Colonel Amamoo mentioned this, that a lot of the risk we talk about, that risk already exists in other forms. For example, allies pulling out. So to ask more broadly, how is space different, or is it different? We rely on contractors. We couldn't do conventional war without contractors or things of that nature. And so how is space different, if it's different in that general sense, as far as risk and reliance on contractors or private entities?
I think common sense tells you that space is extremely different, but legally, I don't think space is very different. I think the questions we have about space seem novel, again, just because the activities are new variations of things that we've done in the past, very similar to the other legal debates we've had over cyber activities, very similar to other legal debates we've had over the use of drones. In each case, they're new capabilities, but they're being used to support military operations, and the legal framework in general is sufficient to address them. So I agree. I mean, this is the use of commercial entities to support military operations is not new. And then how we protect them, I don't think it's a clear definition, but the requirement to provide some protection just for the commercial entities of our alliance or of our individual states, that remains the same, I think, for space. What we would do in response, though, I think that is not different for space, but that's where it's impossible to get an answer preemptively, especially since, unlike the history we have with more conventional warfare, there has not been an agreed upon armed attack in the space or cyber domains. So it's hard to now, aside from theoreticals, go through what some specific requirements would be. So I think in the stage we're in now, it's going to be heavily dependent on the facts of an individual incident. But again, not so different than it would be in the normal conventional commercial context. In the traditional context, yes, we use commercial assets for shipping. Clearly, an attack on a civilian commercial truck, again, depending on the cargo, but most likely would be prohibited. Were there to be an attack on such a target, though, what would happen, though, I think is still unknown, because again, it would depend on the specifics. If an adversary runs one of our supply trucks off the road, again, we're not going to declare Article 5 over that. But there's clearly much grander scale attacks that on commercial entities of our nations that we would recognize as an armed attack without question. I think space right now is just in the same quandary of it's unknown. It would depend on the facts of the case. There could be many actions that we then agree are an armed attack, even though they're on commercial entities that are just supporting military operations, but it's still, because there's no history of that and there's no history of decisions, it's still going to be up to the nations to decide when such an event occurs.
I don't think it's necessarily different as well. I think you've got some differences and you've got some different rules and some different obligations through the Outer Space Treaty, but that can be the case in any situation. You can look context. Each specific situation is context specific, and you will have perhaps in some circumstances lex specialis rules that apply, and I think that's the same for space. I think that not necessarily the difference, but the thing with space is it's key to integration. It's key to integration of all these other domains, and there's that real sensitivity of preserving space and preserving the sustainability of space. And I just, that's all I'd probably add.
I concur. So same, I think it's going to be fact dependent. And I think the rules as they exist now, I think what sort of questions you're going to be asking are going to be the same. It's just what sort of preeminence particular rules or questions may take is maybe going to be a bit different.
I'm thinking about challenges to the possibility and to being able to deliver collective security. And if it's underpinned by collaboration, cooperation, and actually collective understanding of what's going on, to what extent do the panel think that that's challenged by the security classification that surrounds what goes on in space? Because that makes sharing and understanding and collective understanding that much harder between particularly different allies who all might have a different level of understanding. To what extent do you think that would challenge our ability to deliver collective security?
I could say from the GCC perspective that I think it does cause us quite a bit of issues as far as sharing with our allies and partners. It's something that I think that we're recognizing that we're trying to get better at. And I think we do have the example of some of the other combatant commands out there, specifically Cybercom and I think SpaceCom, that do a bit of a better job with it, just from what I've seen anecdotally. I would say, again, though, yes, it is an issue that I think there's a lot of people who are trying to ensure that it's taken care of and that it's a barrier where it can be removed. In other words, so that it allows us to kind of shape and better operate together now on this side of any potential issues or conflict.
Ma'am, I agree that it's a huge issue. And I think it's going to be a constant tension always when you're dealing with sovereign interests and trying to work in a type of collective environment. The one thing I think our nations can take away from our responses to Ukraine is just, at least from my brief time here at NATO, we've seen an extraordinary amount of intelligence sharing between allies, much more so than has been in the past in NATO. And while you're still going to have those concerns about national interests and things that nations want to keep classified, I think the nations are seeing the benefits of in preparation, trying to be as transparent as possible amongst their friends versus only sharing exactly what you need at the time you need it. And then you waste time bringing your allies up to speed at that point in time.
Ma'am, is transparency is an issue, and it's an issue obviously because states don't want to reveal their vulnerabilities. Sometimes they don't want to reveal capabilities, and obviously that's not going to change. But having more transparency with national space policies and having commitments to, say, avoid rendezvous and proximity operations when you haven't necessarily got that protection in law by virtue of not having, say, the zones and things that you'd have in airspace, and making commitments to avoid harmful interference. I think that is something that can be done even where that transparency is lacking and going to need to stay lacking because of national security and collective security.
Ma'am, gentlemen, thank you for your time today. I don't want to hammer an old nail, so there may not be an answer to my question, but I guess as I've been thinking through the last two panels on what's bothering me about the commercial nature of space and the role it plays in our warfare, so I understand that contractors in warfare is pretty standard at this point. But what bothers me is weapon systems specifically. And when I think about the role that satellites and certain space assets play in weapon system kinetic chains, we now have an instance where an entire link in that kinetic chain is commercially owned and commercially operated. So when I think about collective defense and, you know, sort of the shifting of burden to a commercial for that armed attack through a space asset, that's where I have a question, either in the classroom or in one of our combatant theaters. You know, is the law looking through a different lens at these commercial actors in that kinetic weapon system chain? And there may not be an answer, I understand.
I mean, I would say I don't think there's an agreed upon answer because again, it's going to depend on what role the commercial asset or space entity has in the link and how it's specifically being used. So there's, I think there's a big range of hypotheticals between simply taking intelligence photos in space and then doing with them what you will, to having a commercial entity do the analysis for you and then inform you of when there are potential issues, to then potentially controlling, as you say, like controlling offensive munitions or systems like through a commercial entity. Again, I don't think there's an agreed upon position. I don't want to propose one. Again, thinking strategically, because as we view what our adversaries are doing and as we plan what we want to do, I think that's part of the analysis that our national commands need to be doing now before we propose possible answers of how we see our own use of commercial entities in the future.
Very much, Major Mahanic and panel. I think you really wrapped up a lot of the issues that came up throughout the day together in this panel. So I really want to appreciate it. Particular thanks on behalf of all the Americans to Squadron Leader Brown for doing the metric to standard conversions for us so that we didn't have to figure that out in our head. So with that, please allow me to present this token of our appreciation.